Good evening, everyone. Welcome to the Board of Adjustment meeting of April 24, 2019. Could we have a roll call, please, Ms. Yothers?
Mr. Elliott.
Here.
Mr. Rabowski.
Here.
Mr. Burris.
Here.
Mr. Eisner. Here. Ms. Turner.
Present.
Mr. Glenzer. Here. Ms. Rich.
Okay, thank you. Let's be sure to silence our cell phones, please. And pursuant to our rules, I'm supposed to start off and state that this is a quasi-judicial hearing. And in a minute, I'll ask our legal counsel to explain the procedures. But briefly, in 1986, the Florida Supreme Court ruled that boards like this have to hold a quasi-judicial hearing. And the word quasi, as we all know, is Latin for close or similar. So tonight's hearing will be much like a trial, as close as we can get. We don't have our wigs or our robes yet from the City Commission, but we're working on that. But in the meantime, we're going to follow judicial procedures as best we can. And now I'm going to call on our legal counsel to explain some of that procedure to you.
This is a quasi-judicial proceeding where the Board of Adjustment acts in a quasi-judicial rather than a legislative capacity. At a quasi-judicial hearing, it is not the board's function to make law, but rather to apply law that has already been established. In a quasi-judicial hearing, the board is required by law to make findings of fact based upon the evidence presented at the hearing and apply those findings of fact to previously established criteria contained in the Code of Ordinances in order to make a legal decision regarding the application before it. The board may only consider evidence at this hearing that the law considers competent, substantial, and relevant to the issues. If the competent, substantial, and relevant evidence at the hearing demonstrates that the applicant has met the criteria established in the Code of Ordinance, then the board is required by law to find in favor of the applicant. By the same token, if the competent, substantial, and relevant evidence at the hearing demonstrates that the applicant has failed to meet the criteria established in the Code of Ordinance, then the board is required by law to find against the applicant. Are there any members of the board this evening wishing to disclose any ex parte communications or conflicts of interest?
I had a meeting with the staff a few days ago just to go over the facts, that's all.
That's neither ex parte nor conflict of interest.
Well, it's in the rules as a conflict, as a ex parte communication, conferences with the staff. So I had that, but I didn't decide my vote at that time, and of course I have not.
Okay. Anyone else have any ex parte communications or conflicts of interest they wish to disclose? Okay. Seeing none, anyone wishing to speak this evening, if you could please stand and raise your right hand to be sworn. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? So sworn.
Okay, thank you, everyone. And again, thank you for your patience. We were scheduled to have the hearing last month, and it was postponed because we didn't have a full board. And now, as you see, we do. We have 5 voting members and 2 alternates. So you've all been sworn, and pursuant to the rules of judicial procedure, for example, you have full rights of cross-examination of all the witnesses, the staff, the applicant, the neighbors, and you have that right. And there's no time limit for any of you. The board has always expressed a desire to listen to everybody. You'll have a chance to argue your case, explain the facts and your argument, and there's no time limits. I would urge you to try and be relevant and not to get into irrelevant evidence, and our legal counsel will explain what that is if it comes up. But our board has always wanted to get the best result possible, and it means listening to everybody and listening to each other. So procedurally, the staff will start first, and then the applicant, and then the residents, pro and then con, is how we normally do it. When speaking, please state your name and address and the relative location of your property to the subject property, which for the record is case number 19-09-482 Riverside Drive along Kramer Bayou on the east side of Kramer Bayou. So you can have cross-examination at that time. So if you get up to speak, it's my thought if they want to cross-examine somebody to do it when you come up. as opposed to after each, let's say when the staff speaks. I don't know if there'll be any cross-examination. We very rarely have it, but you have the right to do so. We'll get to it at the appropriate time if it comes up. Another thing is, when you get up to speak, we hope to have some kind of a visual aid so that everybody knows what everybody's talking about. If there is no such evidence, then it's going to be a problem. You have to come up and tell us what you're talking about, this corner, that corner of the property. So when you get up to speak, please try to understand that not everybody knows what you are saying. When you say this corner or here or there, be a little more specific so we all know what you're talking about. So after all the evidence is presented, then we close the public hearing, and the Board of Commissioners will then, the Board of Adjustment rather, will have their comments and pass a motion. And we hope there's no need to reopen the public hearing. Hope to have all the evidence, then I close the public hearing, and then the board discusses the evidence and the arguments. So any comments after what I've said? Anything from the board? Is that all agreeable, everybody? Okay, then let's start off with our staff presentation, please. Ms. Erwiller, if you would.
This application is to authorize a two-part variance to reduce the required side yard setback and reduce the required rear yard setback to allow for the expansion of a garage on an existing single-family residential unit. The property is located at 482 Riverside Drive. It is located in the single-family residential district R100. And essentially, the applicant is requesting a variance to reduce the east side side yard setback from the required 10 feet to 0 feet, and the north side rear yard setback from 30 feet to 26 feet in order to expand the existing garage. The applicant does have a building permit for review, specifically with this request. Currently, the existing garage is 546 square feet in size, and the proposed garage would add an additional 316 square feet to the footprint of the structure. This property was subject to a minor subdivision, which was approved on June 7th, 2013. At that time, when that subdivision occurred, this residential unit was the only residential unit on the properties, or on this property. Subsequent to the lot split, there has been an additional residence built in the rear. When the subdivision was created, a 50-foot easement was put onto the property in question, essentially to provide access to the rear lot to allow for the lot split to occur. With that, the existing residence has a 28.5-foot setback to the north or the rear property line according to the survey. And the R100 district requires 30-foot rear yard setback, which is what the basis for the variance is for. They're essentially wanting to bring that proposed garage addition in line with the existing residential structure, so it doesn't have a bump out or anything, so it looks like it's in conformance with the existing structure. With that, the review criteria, based on review criteria 1, the need for the requested side yard variance arises out of the fact that the property was reconfigured in 2013 via a parcel lot split, including the 50-foot private road easement. The private road was created in an unusual lot line configuration on the east side of the lot. However, the private road itself is not unique to the property. The city's subdivision standards allow the reservation of access ways serving subdivisions to be privately owned and maintained. There are other such properties existing in the city as outlined in the code requirements listed in section IB of this report. The city requires setbacks for any property to be measured from the lot line of the public roadway or from the right-of-way edge of a private roadway. Staff has researched the lot split and has not been able to identify any written evidence that the setback standards should not be followed. The need for the requested rear yard variance arises out of the need to again align the garage addition with the existing residential structure. This presents the physical limitation on the property caused by the configuration of the existing residence in the property line that was created in 2013 with the minor subdivision. The existence of the private roadway easement is not a special circumstance, as this is criterion 2. Warning, the granting of the variance is not unique to the property since there are other private roadways in the city. The subdivision was approved on June 7th, 2013, and the private road easement was recorded on June 25th, 2014. The applicant purchased the residence on August 26, 2016. Criterion 3, little enforcement of the dimensional standards would not limit the applicant's ability to enjoy reasonable use of the land since the property already has an existing 540 square foot garage. The existing garage, driveway, and parking pad meet the minimum standards of the Land Development Code, providing at least two parking spaces for a single-family residence. The applicant has stated that the standards limit their ability to improve their home. However, deprivation of reasonable use of the property has not been demonstrated. Granting the variance would not necessarily confer a special privilege that is not allowed elsewhere in the zoning district, since there are many single-family residences having garages. Again, the surrounding residences in the neighborhood generally have larger garages, according to the property appraiser. This demonstrates that with respect to the size of the garage for the applicant's request for a total of 862 square feet does not disturb the general character of the neighborhood or necessarily confer a special privilege not commonly enjoyed by other residential units, since we already have other units in the proximity of this property enjoying that same benefit. This criterion 5, the granting of the variance would not presumably diminish property values or alter the essential character of the neighborhood, since the area is generally developed with substantial homes, including substantial garages. The garage addition itself would not interfere with the right of others or create a nuisance. The application was published in the Tampa Bay Times, and the property owners within 200 feet were noticed. There has been at this time several responses, which are all in your backup and have been provided to the board for their review. At this time, the staff recommendation is that the request does not meet the review criteria established in 215.02B of the Land Development Code. Therefore, staff recommends denial of the variance for relief from the minimum rear setback and minimum side yard setback requirements.
Okay, thank you very much, Heather. Glad to have you back. Does the board wish to ask questions of Heather now, or do you want to hear from the applicant? Any thoughts?
I'd like to ask a question. On Exhibit 3, page 2 of 2,
What does that one look like? Just
that's with the yellow house,
Exhibit
Oh,
2,
gotcha.
the yellow rendering.
Thanks.
Exhibit B.
I'm sorry.
It's the big one.
Okay, what is the distance around midway on the house on the west side from the right of way and to the house structure itself?
The west side?
I'm sorry, the east side of the house. I apologize.
The east side of the structure to where?
At the center, towards the center of the house, the easement looks like it's about 7 feet or 3 feet.
It's probably pretty close to that. It's a 50-foot right-of-way the whole length in. It kind of bumps in and comes really close to the house.
Why did the city allow that in 2013 to happen?
I can't answer that question. I wasn't here in 2013. They required a 50-foot easement, and that's how the 50-foot easement was platted.
Okay,
Or recorded, in this case, not really platted.
thank you. That's all I have.
Any more questions of the staff at this time? I'm sure there'll be more questions later. Seeing none, then let's hear from the applicant, please.
Good evening, Mr. Chairman and members of the Board of Adjustment. Thank you for allowing us to be here tonight. My name is Cindy Terrapini. I'm with Terrapini Planning Strategies at 128 East Tarpon Avenue in Tarpon Springs. I represent the applicant, Sally Diener and Vic Randolph. We have a presentation with all of my exhibits in the exhibit book, also on the overhead, but I also have them in a book so that you can look at them more carefully. I have 8 sets, so maybe the staff and the attorney could share one. I want to be sure that Ms. Yothers gets one for the record, please. the same documents that are in the booklet that I'm handing out to you are also, they're going to be on the overhead. And do we know how to advance? Well, hopefully I'm technically proficient to do this. I'm not sure if I can talk and do the computer at the same time, but I hope so. First of all, these first two exhibits are from your package. They kind of explain where the site is. Before we get into that, I do want to correct one thing that's in the staff report. It's on page 2 during the background discussion. It says, the staff report states, let's see which paragraph. It's in the first paragraph of the background. It states, the city allowed the applicant at their request to designate the south side of the property as the front yard, making the north serve as the rear and the east serve as the side yard. First of all, the applicant didn't designate that. The front yard is always whatever is, by your code definition, whatever is adjacent to the right-of-way. They do have 50 feet of right-of-way on Riverside Drive, so that's obviously the front. The north property line is the rear, and the east and west are the sides. We don't have any disagreement. I just want to correct that we didn't ask for that. We're not deviating from the code in any way on that. The purpose of this is for the expansion of a garage, and we have two areas where we're asking for the setback variance, the north and the east. It is due to the unusual shape and configuration of the site and the location of this access easement. The word is easement. It is not a right-of-way, and we'll talk about that in more detail. It is an easement. So again, let's go to the first exhibit. This just shows the general area. After you go on, if you're on Riverside and you go over the Yacht Club Bridge, just as Riverside starts to turn south and go along the bayou, that's where the property is. And that 50-foot ride, they have a little strip that comes out to Riverside that is 50 feet wide, and that's where you access the property. So here's the same exhibit showing the site, but with an aerial. It's a little hard to see. The aerial I have in the packet for you, I think it's the next exhibit, will show a little closer in on the 3 lots. Yeah, this is in your packet as well. This kind of hones in on the site we're talking about. Where the blue dot is the house that we're asking for the variance about tonight. You can see on the right side, to the right of that house, you can see the pavement area. That's the private driveway that serves both my client's property and the property to the north, the Zellers. That driveway is about 25 feet wide. It gets a little wider right at Riverside, but it's about 25 more or less along the east side of the property. This is probably the most important exhibit to explain what's going on in the site. You can see the outline is the overall site that we've been talking about. The little pink rectangle is the garage expansion area. It's immediately adjacent to the existing garage. It's really the only location the garage could be expanded logically based on the floor plan and the driveway and all the other factors that why someone would add a garage on. The yellow, everything that's outlined in yellow is the 50-foot wide easement. It was approved as an easement, not a right-of-way. The client owns that 50-foot wide easement and pays taxes on it every single year. It is not a right-of-way. It is not dedicated to the public, and I'll have a document to show that. The blue that's kind of within the yellow, kind of on the eastern side of it, is showing the approximate location of the driveway that you saw in the earlier exhibit. So the blue is where the driveway physically is. The yellow is the entire easement. So you're probably wondering, how did this minor subdivision get approved? How do we get to this situation where we basically have a flag lot? Well, first of all, the city does allow flag lots, and it's in section 23.03. And it allows a flag lot if you go through the minor subdivision process. And it's there's some criteria in there, but obviously the city found that it met it. The most important one says that the driveway will be at least 20 feet in width and shall be paved. Clearly the site meets that. The driveway is about 25 feet in most places, and it is paved. The Exhibit 2 that is in your book and have here, where there's a couple of pages, but we'll just walk through it, is the minor subdivision the city approved in 2013. Originally, and maybe, I know we can't go back, but we'll have another exhibit that shows it. This lot and the property to the north, the home to the north, were all owned by one property owner, the Bernsteins. The Bernsteins own the whole piece, and they're the ones who asked for this minor subdivision. And what they want to do is leave the house that exists today, the house we're talking about that has the variance, and allow a new lot to the north to be created, which was vacant at the time, now has a house on it, and create that second lot. And the city allowed that. And if you'll page through those exhibits, it shows this first page is the city's approval in 2013. It sets out the setbacks for the lot to the north, where there was no house at the time. Then it has a perpetual easement and maintenance agreement. That's a private easement between my clients and the Zellers who own the property to the north. They didn't own it at the time, but they purchased it later. And if you look in that first page of the easement document, it talks about maintenance of the private drive, how the private drive has to be repaired. And then if you keep paging through that, you'll see there's a private roadway legal description. And then the last page in that, the specific purpose survey, is basically the exhibit that I showed you earlier, the site itself, showing the paved area, the 50-foot wide easement, and the driveway, that paved area on that east side. Again, it states on the specific purpose survey, it is a private way. It is not a right-of-way. And again, this minor subdivision met the minor subdivision requirements of the city that only allows you to have a total of 2 lots, which was what was done. And then secondly, it had to meet the flag lot requirements, and it met all of those. And the most important, again, is that it had a driveway of 20 feet in width. Then I just want to give you a sense of how this looks on the ground. It's kind of hard to tell from aerial, so I have some photographs that I'll go through and explain those. Again, these are the pages from the minor subdivision approval and the easement that was recorded. It's a little hard to see on the overhead, but this is the page I was talking about, the specific purpose survey. And if you look on where that 50-foot wide easement is on my client's property, it's called a private way. When it gets onto the north property, which was vacant at the time, now has a house on it, that private way was reduced, an easement was reduced to 25 feet in width. Okay, so this is the first photograph. If you were coming from Riverside, and this is right at Riverside and the driveway entrance into the property. The Dina Randolph home is on the left. The Zeller home, that's the north property, is right at the top of the page. It's the big white house at the top. This is looking west at the front door of the house, on the west facade of the east facade, but it's the front of the house, and I'm looking west towards the water. The water is behind me. This is again looking west. You can see the garage is that part of the building that's sticking out on the right of the photograph. Where the truck is basically where the garage is proposed to be. And this is another picture. Now I'm standing in the driveway looking south. Back at, you can see those windows are the edge of the existing garage. And where the truck is basically, that's the expansion area proposed. And so the expansion will go from the existing garage to about where the truck's right tire is, if you can imagine that. So it goes from the existing building to the edge of the truck. And then this is standing at where the new edge of the garage will be on the Dina Randolph site, looking north to the property to the north. And the only reason I took the picture is just to show 2 things. One, the house on the north extends further out than our garage will. So that's really just the purpose of that, to show that. And also it kind of shows it, and we'll show it more clearly on a survey, but the house to the north is about set back 12 feet from the common property line. If the variance is approved that we're asking for tonight, the new garage will be set back 26 feet. So we'll be twice as far away with our garage than they are to our common property line. Before we leave the site, just to talk a little bit about, well, everybody also you always want to say, and I ask the clients this myself, isn't there anywhere else you could put the garage where you didn't have to go for a variance? Let's make your life simple. let's not go for the variance and that whole process. It's timely. It takes some time. It's expensive. And so clearly, now that you've seen the property, I think you can see that the only place to expand the garage is next to the existing garage. You wouldn't put it on the water side. If you put it on the south side, there's no garage there. You would be you'd rearrange the entire flow of the house. So that's really the only place that we have is to put that garage. And the purpose of the garage expansion is the garage opening itself is not wide enough for today's size cars. That's problem number one. Problem number two, they do want to have additional area for storage. They're an active family. They live on the water. They're active in other sports activities, and they want to have room to store that equipment as well as being able to get 2 real-size cars into their garage. So the variance request, let's talk about, there's 2 parts to it. The north property line, what's required is 30 feet. We're proposing 26. The current garage is about at 28 and a half. And you can see from the site plan that you have, that it's in Exhibit 1, because of the way the garage is angled, as we go out to the east, it gets closer on the north side. So even though it's at about 28 and a half today, when we add in the new garage, it'll be 26 feet. So keep in mind that the garage that's existing at less than the required setback today, that house was existing when the Bernsteins separated this house from the new lot and created that new lot. Why the city didn't make them have the 30-foot setback, I really don't know, but that's existing as it was when the minor subdivision was approved. So the new garage will be twice as far away from the Zellers property than the Zellers house is from the applicant. Again, the garage, if approved, will be 26 feet from our common property line. The Zellers house today is 12 feet from that same common property line. If the variance is not approved, the applicants will be denied a reasonable use since they won't be able to have a functional garage, just like their neighbors, the Zellers, and other homes in the area. You've seen correspondence from the Zellers objecting to this variance, but that correspondence doesn't identify any legitimate reason objecting to it. In fact, their opposition is what my grandmother would call the pot calling the kettle black. The Zellers' home is set back half as much as ours is, and the Zellers seem to be applying a different standard to the applicants than they do to themselves. So I'm happy to hear if they have some other comments today. We're interested to hear what those are, but at this point I don't hear any reason that rises to a legitimate objection to a variance. So that's the north property line. On the east property line, it's again for the same garage, but there's much different issues here. The required setback on the east property line, because again it's a side, is 10 feet, and what we're proposing is 50 feet. And you're saying to yourself, well, why is she even here asking for a variance if you got a 50-foot setback? Which I asked myself the same question I asked the client that when I met with them. The reason is that the city staff is treating this easement as a right-of-way and saying that you have to measure the setback from the inside edge of that easement. Well, I don't know of any situation where the city does that, and your city code specifically does not provide for that. In fact, it provides the opposite. Exhibit 4 if you turn to that, there's a definition of what a right-of-way is. And I'll just read that. A strip of land acquired by dedication, prescription, condemnation, or purchase for use as a road, crosswalk, railroad line, electric transmission line, oil or gas pipeline, or similar use. A right-of-way reservation is a strip of land intended for future purpose as a right-of-way. The term right-of-way does not include easement. Let me repeat that, the most important part. The term right-of-way does not include an easement. They are 2 distinctly separate legal issues. A right-of-way, as you all know, is owned by the city. The city maintains that right-of-way, and pretty much the only thing you can do in a right-of-way is drive on it. You might have some landscaping in it, you might have a sidewalk, but a right-of-way, most of the right-of-ways in the city are for streets, for roads. There are other right-of-ways, like they said, for gas pipeline. We typically don't have that in Tarpon Springs. An easement, in contrast, is owned by the property owner, just as it is owned by the Mrs. Diener and Mr. Randolph. They pay taxes on that. It counts towards their lot size. It counts towards their density. And you should be able to measure the setback from that property line, not the inside edge of the easement, which is what the staff is saying. In May 2017, the planning department confirmed in writing that this easement is an easement and not a right-of-way, and that's in your documents, page 4. Exhibit 4 is a letter written on May 26, 2017, and this was in response. The clients have pursued quite a few different options to try and get them the garage expansion. And they thought, well, if the city's saying it's an easement or maybe it's a right-of-way, why don't we try to vacate it, and then we won't have that issue anymore, or at least make the easement smaller, make the right-of-way smaller, because the city has said various things about it. The letter says, the city public has no legal interest and no right to the ingress, egress over the easement on your property. So in May 2017, the city's saying it's an easement, number one, and they're also saying the city can't vacate it because it's a private easement between those two property owners. And we agree. It is a private easement between my clients, the Dina Randolphs, and the property owner to the north. So the letter, I agree with the letter. It's correct. The city really doesn't have any way to vacate a private easement. And they said, well, why don't you go talk to your neighbor and see what you guys could work out. So with this letter, the city again declared that it is an easement and not a right-of-way. So the setback should be measured again from that. We're merely asking that the setback be measured from the property line, just as the city measures all other setbacks in the Land Development Code. However, even if the city said, look, we recognize that this is a private easement, but you guys have to maintain the access to let the people to the north through. Okay, we would agree with that. What if but the garage expansion will still be 25 feet from the edge of the driveway. 25 feet, where 10 feet is required. The garage expansion will not be in the easement, it will not be in the driveway at all, and it will not encroach into either one of those. And in fact, the closest point of the driveway that could possibly have an effect on the neighbor, the garage expansion will be 25 feet from that closest edge of the driveway. As further evidence that the setback should be measured from the property line, in Exhibit 2, this was the letter where the city approved the minor subdivision, and in that they said what the setbacks would be for that new lot when it were developed. And guess what? They said in the letter that setbacks would be measured from the property line. If I could refer you now to Exhibit 5. Exhibit 5 I obtained from the city records. It's the as-built survey of the Zeller home, the property to the north. The Rodney Chapman letter, when he approved the minor subdivision, says that the home had to have, on the east side, same side we're talking about for the Dina Randolphs, on that east property line, it had to have a 25-foot setback. And it said the setbacks could be measured from the property line. Well, when you look at the building permit that was issued, and this is the as-built survey, the east edge of the house is 33 feet from that east property line. So if the city was requiring it to be 25 feet off the easement plus the 25-foot wide easement, the house would have had to have been 50 feet from that east property line. It's not. It's only 33 feet. So clearly the city agreed. They followed that the 25-foot setback, again, was measured from the property line on the Zellers, our neighbor exactly to the north. We're just asking you as a Board of Adjustment to give us the same treatment as the Zellers got. Let us measure our setback from the property line. There are 5 criteria that have to be met, and I'd like to talk about those briefly. The city staff has already agreed in their staff report that we meet numbers 4 and 5, so I'm going to concentrate on 1, 2, and 3. So let me go through those, if I might. The first one is that the need arises out of the physical surroundings, shape, topo, or other physical or environmental conditions. There are a unique situation on this site. The shape is a little unusual, but the most unusual part is the city is misinterpreting their code and requiring a setback off of within the private property as opposed to from the edge of the private property. If we were not allowed to use this easement at all for anything, which is apparently what the staff thinks, the easement is 37% of the total lot. It's quite large because it's 50 feet wide. And so to say that we can't use it for anything, not even as part of our setback, really violates my client's rights and property rights for this site. The clients clearly understood this when they bought the property. They understood there was a 50-foot easement. They understood there was a driveway. They understood they had a maintenance obligation between themselves and the Zellers that actually had not bought the property at the time, but they knew that whoever bought that, they would be partners in that deal. They understood all that. The only thing they didn't expect was that city to calculate and measure the setback from the inside edge of this easement instead of from the property line like it's measured everywhere else in town. The second criteria that we believe we have met is that the special circumstances have not been self-created or resulted from an action of the applicant. Well, they clearly were not. The minor subdivision was created and done by the Bernsteins, the previous owner. It was done in 2013. My clients purchased this property in 2016. So they did not create this unusual situation of the lot being the shape it is. They did not create the easement and the driveway. That all was in effect when they bought the property. The third criteria is that literal enforcement of the rules would have the effect of denying the applicant reasonable use of the property. Clearly, literal enforcement is going to deny them a reasonable use to have a reasonably sized garage, which the staff agrees it's a reasonably sized garage given the surrounding area and other sized garages. But the only logical place to expand that garage is in the location where we're talking about, unless they rearrange the entire floor plan, the entire site, demolish the garage they have, and build a new garage somewhere else. So if the variance is denied, they will not be able to have a garage that's wide enough for 2 cars and for the storage of their sports equipment that they would like. They also have, small boats and I call them ski-doos, the jet skis, and so they want to store those inside for obvious reasons. The fourth and fifth criteria, again, the staff has agreed that we meet those, but just to touch on them briefly, granting the variance will not confer any special privilege. It's not going to be a special privilege. It's basically a garage to be able to get 2 cars into it and get their equipment into it. The staff has already said it's generally the same size as garages in the area, so there's no special privilege. The fifth criteria, again, the staff agrees we've met this criteria, that it will not substantially diminish property values. Clearly, if you're improving a property and adding a garage that is a typical use that you would have on a residential property, how could you possibly diminish someone else's property value? Let me just give you some dimensions if approved, just to give you the kind of summarize here. If the proposed garage is approved, it will be 50 feet from the east property line. It will be 25 feet from the closest edge of the driveway that we share with our neighbor to the north. It will be located completely outside of the driveway and the easement. It will not encroach into either one of those. And on the north side, the garage expansion will be twice as far from the Zeller's home, Zeller's property, as they are from us. We'll have a 26-foot setback to that common property line. Their house is 12 feet from the common property line. To the east, the property owner to the east will be 52 feet. Will be 50 feet to the property line. Our adjacent property owner to the east, there's a single-family home there. I haven't measured it exactly, but I did eyeball it and kind of tell what it is. It's about 10 feet. So we'll be 50 feet away. Our closest part of our house, the closest part of their house, is 10 feet from our common shared property line. So there's huge distances between the garage expansion and both of our immediate neighbors. If the variance is not approved, it will result in a differential treatment to these applicants, since they won't have the same privilege to have just have a simple garage, just like everyone else in the neighborhood. We do have letters of support that you saw from some of our neighbors who thought that there would not be any harm to them and thought it was a good idea to support the variance. I would like to reserve the right for rebuttal, and I certainly would be happy to answer any of your questions or go back through any of the exhibits if you like. Thank you very much.
Mr. Chairman, may I make a clarification? Mr. Pani, there was a lot of discussion that you had about interpretation of the code as to whether it was a right-of-way or an easement.
Mm-hmm.
Are your clients asking for an interpretation of the code and an appeal of the decision of the building department under Section A of under subsection A of Section 215 of the code, or are you presenting evidence in support of a variance from the code?
Well, when I got involved, this is the long answer. When I got involved, the application for the variance had already been filed. I'm well aware that we could have filed an administrative interpretation to challenge that part of it. Quite frankly, the application had already been filed. There was a public hearing scheduled. So we just decided to proceed along this path and ask for the variance. What I'm hoping that I'm showing you is that there's many legitimate reasons to approve the variance. I don't agree. That's not saying that I agree with the staff's interpretation about where it should be measured. And I guess I would like you all to, if you do decide to do it, make it clear that the setback is X feet from the inside edge of the easement, whatever that number is. And really, in our estimation, it's 0 feet or 1 foot. So no, I'm not asking for an interpretation. We do want to proceed with the variance. I'm just providing evidence as to why it complies with the variance criteria.
Okay, so I just want to make that clarification for the board, that the board is only to consider the evidence and apply them to the criteria for a variance. And Ms. Terrapini, on behalf of her client, is not asking for an interpretation of right-of-way versus easement.
But I do think that y'all do have the obligation to take a look at what the code says. And I mean, everywhere in the documents, it's an easement. And y'all can take that information and evaluate that as part of the variance application.
So let me ask this, please. If we could ask Heather, who signed the letter that stated that it's an easement. Do you agree with the letter that you wrote?
I do agree with the letter I wrote, but you can't have a minor subdivision without some type of right of way. There's a section of code that states under the minor subdivision.
Can you speak on the mic, please?
There's a section of code on the subdivision, minor subdivision section, section 1B. Each lot shall abut a public or a private right-of-way for the required minimum lot frontage of applicable zoning district. So the reason why we determined that it is in fact a right-of-way is because you can't have the Zeller's lot exist without determining that that right-of-way occurred in order for the subdivision. So that is the reason why. I don't dispute that it's an easement. I don't dispute it's an easement, that this was done creatively, okay? Under my watch, we wouldn't be doing it this way because this is not meeting the standard.
Well, do they own the property or not?
They do own the property.
So then it's an easement.
It is an easement, but we do have other public right. We have other private right-of-ways that are owned by other people. They are not actually owned by the city. And sometimes the city doesn't have right to even traverse them unless they're granted those rights. Those also are functional private streets, private right-of-ways that are easements and sometimes private streets. It just depends on how they were designated and at what time they were designated.
Since that's the case, why couldn't you measure from the line that she is stating versus the line that you have chosen to?
Well, we're making the determination that it's a private right-of-way. As such, we're using that section of 131 or 130 to determine under right-of-way that it's measured from the actual right-of-way line, not from the actual property line.
For what reason again?
Because we're determining, we're calling it a right-of-way.
Even though it's an easement at the same time?
Recognizing that it's an
So you could just as easily measure it from the other measurement, or would there be some detriment to the city if you did that?
We're following the code. We are following the code as we read the code.
Can I ask a question about that? Ms. Erweiler, have you read 23.03 about flag lots?
Yes.
And why was that? It specifically says if you do a minor subdivision, it calls out the rules under which you can do a flag lot.
That's true, but you still have to read the minor subdivision section. The minor subdivision section, as I read, says any lot must abut a public or a private right of way for the requirements of the minimum lot frontage for the applicable zoning district.
Doesn't a flag lot, by definition, not have one lot that does not abut a right of way?
It may very well have in the definition, but you can't have one section saying go to this section, follow that section, and that's how you get there if you don't have a deviation in that minor subdivision section that leads back to that section, which isn't here. So I agree that the construction is not correct here, but at the same time, these are the provisions of the code, and we're interpreting the provisions of the code as they're written,
And
we feel as they're written.
Excuse me. And in the minor subdivision that was approved by the city in 2013. Was the 50-foot wide area, let's just call it an area right now, was it approved as an easement or a right-of-way?
I can't answer how it was approved. All I can tell you is it was approved, and it was written in and adopted into the record as an easement. So I don't know how they actually approved it. I wasn't part of those hearings, so I don't know that discussion on how they got there.
So let's forget about the motives. The bottom line is it was approved as an easement in 2013. Thank you. So it is an easement. Thank you. Do you have any other questions for me, Mr. Chairman? Otherwise, I'll sit down, and I'm sure there are other folks that might want to speak.
Well, I have a lot to say, but I don't know when is the appropriate time. Does the board want to ask questions of the applicant now? Or you want to hear? You want to hear from the other people, and then we'll go back to the applicant? Is that okay?
Sounds reasonable.
I'd prefer to do that. I'd like to hear what everybody's saying, and then we'll get back to us.
If you don't mind.
Sure,
Okay, all right,
absolutely.
just don't go
Sure.
away. All right, let's, anybody in the audience wish to speak in favor of the application? Anybody other than the applicant? I'm sorry. Any neighbors wishing, anybody in the audience, seeing none? Anybody wish to speak in opposition to the variance? Yes, sir, please come forward. State your name and your location.
Good evening. I'm Christian Zeller. I'm the neighbor at 480 Riverside Drive. I'm to the immediate north. Thank you, Ms. Terrapini, for leaving the survey up there, if I may use it too. So you see my property right there. That's where we live. Ms. Terrapini, I don't think that my property lends.
Sir, if you could address your comments to the board, please.
I don't think that Ms. Terrapini's comments lend itself to comparison to my property. I'm not applying for anything. The applicants are. My property is zoned R100, and an R100 property has a 25-foot rear setback, whatever side setback, I think between 10 and 12 feet or 15 feet on one side and 30 feet to the front. I have 43 feet to the front. I have 17 on my north side. I have 12 on my south side, and I have 33 to my east. So I'm in full compliance with the R100 setbacks. What leads into my property, what you see at the very, very right corner there, is not a private way. That's the 25-foot setback. There is no shared drive there, none of the sort. So comparing my property to the subject property makes no sense, because what we have across this subject property is a shared drive. And I am not a real estate lawyer. I do not understand this code. I don't know how you interpret easements or how you interpret the right-of-way. But what I do know is that the title is not dispositive. It is the subjected use, what we use the property for, which matters. And with that, it is a right-of-way, because I'm driving in and out there every day, and so does my family. And we have a right to pass through there. So while there is an easement agreement, a perpetual easement agreement that comes with a maintenance agreement and what have you, which is a private agreement, it's nevertheless a private road that goes across 482 Riverside Drive, which creates a right-of-way for me to go in there. And I will also suggest to you, Ms. Terrapini, I think, mentioned that the Randalls pay taxes on that, and that is correct. But if you do a cursory review of the property appraiser's records, you will see that they are getting a credit for having a right-of-way across their property. That's what the property appraiser says. You know, that is not what I have. Now, with respect, and I understand, you know, that this is like presenting a resume. We all want to look as good as we can when we do those things. And so Ms. Terrapini did a great job for the Randalls, you know, and pointing out to you over and again on how the Randalls property is 26 feet away from mine, and I am 12 feet to their property line. Well, of course I am, because the 12 feet are my side, and I'm in compliance with the 12 feet on my side, and their 26 feet is their back, and they're not in compliance. I mean, that's already a nonconformity, because they ought to have more than that in the back. If they were to get that variance granted, I think they would be encroaching on their rear setback. So I don't think that ought to be compared and that ought to be taken into consideration. The fact of the matter is that the subdivision of 2013 was a bargained for agreement. That's exactly what it was. I was there. I was part of it. And the restrictions have been open, notorious, they are recorded. And the Randalls knew that. They looked at it, they considered it, they bought it. I will also suggest to you that the purchase price of their property was part and parcel of that consideration. I did a comparison of the property prices when they bought in 2015. And if I may ask Ms. Woodville for a hand me down here. The subject property was bought by the Randolphs for $443,800. That's $150 per square foot right on the bayou. Right across the bayou, at the same time, and I highlighted the numbers for you on the property records, at 612 Bayshore across the bayou, a property sold for $375,000, 1,424 square feet for $263 a foot. The property next to it, in the same year, 1,807 square feet, sold for $460,000, or $255 per square foot. So I'm suggesting to you that the Randolphs paid over $100 less for the waterfront property, and I'm suggesting that that is because of the deed restrictions that the property is burdened with. The right-of-way, the big setback, the easement. Now, the Land Development Code, from what I understand, provides for 2 parking spaces for an R100 zone property, and it's my understanding that the subject property is also an R100 zone property. The applicants have a garage. I understand Ms. Tarapani's argument that it's 546 square feet and you can't fit 2 cars in there. Let me put them in there for you. Seriously? I mean, that's a normal garage. A normal garage starts out 20 by 20. That's 400 square feet. A medium-sized garage is 24 by 24, and an oversized garage is 26 by 26. That's what we have in Pinellas County. So the Randall's garage falls squarely within a medium-sized garage with 546 square feet. Now, right outside the garage, and Ms. Tarapani showed you a photo there, there's a gravel parking spot, and 3 cars fit there, and they have an additional gravel parking pad for 2 more cars. And again, if I may ask Ms. Over for the picture, hand me down. Where you can park 2 more cars, and the cars are actually parked here on the pictures if you take a look. So the Randalls have parking spaces for 7 cars.
Mr. Chairman.
Mr. Burris, question?
Can I interrupt
Yes,
you
sir.
a minute? If it was a bedroom and not a garage, will that bother you?
Let me tell you why it bothers me.
The property they're trying to expand, instead of a garage designation, it was an extra bedroom.
Yes, it would bother me, and let me tell you why. Because it is
Expanding the size of the garage.
Let him finish.
because it is encroaching on the property setbacks. The only reason, sir, why I'm using the garage or parking argument is because the parking and garage argument was made by the applicant. They said they have a 2-car garage and they can't fit cars in there. That's why I'm making the garage argument. It doesn't matter what type of structure it is. But if you wish to talk about the structure, I will tell you why I have an issue with it. And the issue is twofold. The issue is twofold because not only does it encroach on the setbacks, it's already a non-conforming property, and this will compound the non-conformity. And what was not presented here is today that this not only includes the garage, it also includes a nearly 900 square foot second-story storage. So we're not just talking about a little garage extension. We're talking a total garage square footage of 866 square feet once it is completed, plus an 877 square feet second story storage unit, which will also obviously encroach on the over the property line. Yes, sir.
Are you happy with the size of the roadway? Do you have a problem with the width of the roadway?
No, I'm not happy with that, and which is a completely different.
It has to be wider, is that what you're saying?
If you look in your materials, there is a perpetual easement and maintenance
Roadway
agreement.
they have in this picture here.
Yes, you have this picture here, but the written agreement is really is more directed at your question, sir, because that particular agreement states that there is to be no encroachment within this roadway, and this is not the subject of tonight's hearing, and I think it's outside of what is being discussed today. You know, that roadway has been encroached significantly with landscaping and building, all of which is against the language of the agreement that is before you. So talking about whether the width of the roadway is wide enough, I don't think that is the subject matter of this hearing.
Is the city planning to
Can
expand?
suggest, I have a lot of questions, so I understand why you want to get into it. I'd like to have the applicant or the audience finish all their presentations. I'm keeping a lot of comments to myself. I understand. You'll be first, though, okay, Mr. Mayor? All right, if you could finish up, sir, please.
Thank you, sir. You know, I suppose emotions run high with these things. I mean, we all talk about our own properties, and so do the Randalls, and so do we. But it seems to me that at the end of the day, this is an R100 zoned neighborhood. And as an R100 zoned neighbor, I must be able to have a reasonable expectation that the neighborhood develops within the confines of that code. That's why we bought that. That's why other neighbors bought that, because we have those various setbacks, and that's what I feel that I am entitled to as a neighbor there. And so this variance request, by the way, is opposed not only by the city and by me, it's opposed by 2 other neighbors. And when I talk about neighbors, I am talking about contiguous neighbors. I'm not talking about neighbors 4 houses down the road. And again, if I may bother you again, Ms. Louisville, I have the site plan here for you to take a look. The subject property is on there, and I've highlighted for you in red the neighbors who oppose this variance, and I highlighted for you in green, in all fairness, the neighbors who are supporting this variance and who have written letters on behalf of the Randalls. And you will see that the neighbors who support the Randalls, there are many houses down the road. As a matter of fact, they're all over 350 feet away. They can't even see the subject property from their home when they step out. However, there are 3 neighbors opposing the variance are all contiguous neighbors, completely abutting this particular property. Thank you, and I'll be happy to answer any questions later if you have them.
I just wanted to comment to the exhibits that were passed out. I do want to make sure that Ms. Terrapini gets a chance to view them and before she makes any type of a rebuttal argument, since she hasn't necessarily had a chance to see them.
All right, thank you, sir.
I have one quick question before he goes.
Can you wait? Okay.
Just because he just handed it
All
out.
right, okay.
Just a quick
All right,
question. The handout that you handed out that has the color coding.
Would you be on the
Yes,
microphone?
sir.
John?
The handout that you got that has the color coding, is the red the contiguous neighbors that you're talking about?
That's correct.
And the green? Okay, so that's the color coding of what we're talking about.
That's correct,
Of
sir,
your
yes.
last statement. Okay,
Yes.
that's all I wanted. Sorry.
Thank you.
All right, any other people in the audience wishing to speak in opposition to the application?
Yeah, I'm a Sharpie. Good evening, thank you. My name is Greg Leocuris. I've resided at 478 Riverside Drive since 2001, and I 100% strongly stand behind the city's decision to deny this variance. In addition to my neighbor Christian, everything my neighbor Christian has pointed out, I not only believe but know that this variance will impact the value of my property. The proposed build is approximately 50 feet away from my property line and my view of the Kramer Bayou. When I was reading through the application 19-09 requested variance, I was taken by the Roman numeral number 5, that the review criteria of variance, and it states, granting this variance will not substantially diminish property values in the surrounding areas. For me, it will. It will block my view from my balcony in my master bedroom, plus my views from all corners of my house that I've enjoyed for many years. And my neighbors have expressed the same feelings. So I'm sorry, but all this for storage. They want to go up 30 feet on top of this proposed garage that I guess I didn't really hear about in this hearing, but in the city's plans, they were saying they want to go up. That would block my view for storage. I just don't really understand that point of it. I don't know much about setbacks and so forth, but I believe the city is doing a diligent job to make sure that they enforce these requirements. I just want to thank the committee for hearing my strong feelings, and it's a very important matter. Thank you for your time.
Thank you, sir.
Which house is his?
Yeah, could you please describe where your property sits or
My
properties?
house is east of the proposed variance, directly east of it. So before you pull into their driveway,
On the curved
before you get
lot?
before you get into their driveway, where their easement is, I'm the house. If you're coming from the yacht club, heading towards Howard Park, I would be the house right before their driveway.
And you also own the vacant lot on the other side of their house?
I do, yes, sir. I bought that from the Bernsteins as well.
Okay, any other people in the audience
Thank you.
wishing to speak who have not spoken yet?
Hello, my name is Brad Giles. I'm the resident of 463 Riverside Drive, located southeast of the house we're discussing. I'm a neighbor in good standing with Vic and Sally, and I'm very much a live and let live neighbor. However, the addition of the second story over the garage would block a valued vantage of my waterfront view of Creeper Bayou. And it's for this reason that I oppose its construction. I believe that understanding among neighbors is important and hope that this decision will not negatively impact our relationship.
Okay, thank you, sir.
One second. You're on the opposite side of the street?
Yes, I'm on the south and slightly
I know,
east.
I think I just want to verify who's who in this. Okay, thank you.
Okay, all right, thank you. All right, I guess it's time now for board questions. Let's, Mrs. Terrapini, you wishes to say something? Go ahead. Okay.
Whenever you think it's appropriate, Mr. Chairman, I do have rebuttal to some of those comments, and I have some more exhibits I wanted to show you, but you tell me when you want to do that.
What's the board's preference? Any thoughts?
No, I hold it.
All right, why don't you make your rebuttal and your documents,
Okay.
you can present.
I think might be helpful. There is an exhibit that shows, we can point to the map where these different folks live. Maybe that would help kind of solidify that. Would that be helpful?
I think we know where they are.
Okay.
Okay.
All right. First of all, I neglected to mention this, but it's clearly written in the easement agreement. The easement is not dedicated to the public. It is only dedicated to two property owners, the Dina Randolphs, my clients, and the Zellers to the north. And in fact, as you saw in all the documents, the easement terminates at the Zellers' north property line, and there is no right-of-way or street or anything else to the north of that it can possibly connect to. It butts up against another piece of private property. Again, there was someone trying to imply that somehow that the Dina Randolphs knew about it and they created this problem. They did not. The minor subdivision was approved by the city in 2013. You have that letter in front of you. They purchased the property in 2016, 3 years later. So did they know what they were getting? Yes, they did, but they did not create any of these issues. Some of the comments made by Mr. Zeller, clearly you all know this, the purchase price of the Dina Randolph's property or any other property in the area has nothing to do with the variance. The number of parking spaces they choose to have in addition to a garage also has nothing to do with the variance. I'd like to show, also I'd like to mention, I think you'll see it on this photograph I'm about to show you, that the Zellers' property is 2 stories above garage. The Dina Randolph's property is a 1-story house. So how that's going to affect Mr. Zeller's view or impact him, I really fail to understand that, and I'll pass this out to you all. So what you're going to see is a photograph standing at the southern edge of that shared driveway. The White House at the top of the photograph is the Zeller property that we've been talking to that we share the driveway with.
Could you hold it? Just for,
I'm sorry. Thank you.
Yeah, they don't have any.
So again, when I took the photograph, I'm standing at the edge of the shared driveway. The White House at the top of the photo with the red roof, that's the Zeller home. It's 2 stories above parking because it's in the flood zone, as are my client. But it's basically a 3-story property. So to try and make some claim that a 3-story house is somehow being impacted by a 1-story house is adding a small little second floor, not along towards the water view either, I might note. I really don't understand how that really holds any water, no pun intended. The second...
if I may ask just a
Yes,
point of
ma'am.
clarification on the photo. 480, White House, 478, Brown House on the right.
I'm sorry.
I'm just very visual. The brown house on the right, that's 478?
That's Mr. Leocuris. Yes, I was going to talk about that too. So Mr. Leocuris that just spoke lives in a 3-story house, basically 2 stories above parking or storage because he also is in a flood zone. And his property, he didn't buy a view and didn't buy waterfront property, so he doesn't have any right to a waterfront view. But quite frankly, he has it because my client's property, if he looks to the west towards the water, towards the bayou, he's on the 2nd and 3rd floors, and my client has a 1-story garage, a house, with a small portion that will be a 2-story. So how that can be really impact him, and again, it's a view that he didn't buy, he doesn't really have a right to. The third photograph I'd like to pass out. The photograph I just passed out, I am standing on the opposite side, the south side of Riverside, right at that bend. I'm standing in front of Mr. Giles' house. He's the second gentleman who spoke. The blue car there, that's my car. The brown house on the left, that's my client's property. That's where I'm talking about the variance. The white house with the red roof, of course, that's the Zellers that we've been talking about that shares the driveway. And the brown house is just outside the picture. That's Mr. Leocuris' property, our neighbor to the east. So standing from Mr. Giles' property, I fail to understand how he can even see the garage. The garage is going to be about where that tall palm tree is. So I really, visually how that can impact him at that distance, I really don't think that that's possible, number one. And number two is, it's not part of your variance criteria that his view changes as a result of someone else's proposal. Even contiguous neighbors, one of the speakers made the point that the 2 people immediately contiguous have spoken opposition, and that is true. That's Mr. Zeller and Mr. Leocuris. But even contiguous neighbors need to have a legitimate reason for the variance, to oppose this variance. And the fact that this house, this garage, not even a livable space, as Member Burris pointed out, it's the garage area, will be twice as far away as the Zeller's property is from us. I fail to understand how that is a legitimate reason. Again, Mr. Leocuris, his house is about 10 feet from the property line. That's the requirement. That looks like to me, when I eyeballed it, about what it is. You can judge for yourself in the photograph. I fail to understand how, when he has a 3-story building and our garage will be 5 times further away than his house is to our property line, how that is impacting him. Again, we're here because we've tried everything. My clients have tried everything. There's other things they tried with the city that did not proceed. They tried to vacate the easement, as we've talked about. We're here as a point of last resort. They just want to build a garage. They want to build a garage expansion. They've got a lot of things they want to store inside, not have the weather. They want to be able to, people say, someone said, the garage is big enough. The problem is where the posts are, where the structure is for the garage today. You cannot easily get 2 cars in the garage. So it's that, as well as the ability to store items that any normal family would have and would like to store in a garage and not have it sit outside. We've showed, I think, that we've met the variance criteria. The garage expansion will not be in the shared driveway. It will not encroach in that at all, and it will not encroach into the easement at all. It will be outside of both of those. We will have a setback that is 50 feet from our property line on the east, 26 feet on the north. Great separation of distances between the new garage and both of our neighbors, and we respectfully request your approval. I'll be happy to answer any questions if you like.
Okay, thank you. Mr. Zeller, you wish to speak again, please?
Yes, if I may.
Sure.
Thank you, Mr. Chairman, and only because my property seems to be under attack. I understand the emotions and that you got to present it all in your best light, Ms. Terrapini, but I don't have a 3-story house. I have a 1-story house. By code, I must be at least 11 feet. If I want to get decent insurance, I should be at 13 feet. So my ground level is at 13 feet, and I have a one-story house. And underneath it, I have $26,000 worth of fill dirt. So it is not a three-story house, as Ms. Terrapini would like you lead you to believe. It's a one-story house built to code at the flood level. And I also appreciate that our neighbors tried everything. Look, this is a variance application. It's not an entitlement. So the argument that we've tried everything and now we got to get it is just not right. Thank you.
Mr. Giles, you wish to speak?
So I'm not here about variances. I'm not here about property lines. I'm here about a single line of sight. From the north side of my house, my wife's office desk sits in front of a large octagon window. This picture is from ground level. It doesn't display the impact that an additional, it's the up that I have a problem with, not the out. I have no problem with the out. Go out all you want. It's the up. From the north side of my home where my wife's desk sits, where she spends lots of time, 30 hours a week, she can see Creamer Bayou over the roof of this garage. The addition of an extension on that garage will block that view. That's my only opposition.
Okay, thank you, sir. Appreciate it. All right, where do we go from here? Any questions from the board? Mr. Burris, I promised you.
The first.
George, you wanna,
Yes,
whoever you want to talk to, but
I want to ask Mr. Zeller.
Yes, sir.
I started asking you before if you're satisfied with the driveway or the road the existing road that you have now. Are you satisfied with it?
I'm satisfied with driving in and out. I'm not satisfied with the state of the driveway because there have been encroachments, which, again, I must point out, have nothing to do with this variance application. Those encroachments are completely different subject matter, and I do not want to burden my neighbors in this forum with that issue.
Okay. I'll get back to the next question, but I want to ask the city, is the city planning to widen this roadway?
Mr. Bursch, this is, the party is correct. This is not relevant or germane to the variance application here today.
talking about Riverside Drive?
No.
Or
This existing road.
Talking about
the
the
driveway
roadway.
is private.
Okay.
The city has no.
The city doesn't have any ownership.
So in other words, this is not in any way going to widen. It's going to widen whether from Mr. Zeller or the owner of the red house. Will it get wider? You're asking for 50 feet.
Nobody's
No,
asking
no.
for 50 feet.
You already have 50 feet.
No, they're asking to encroach into the setback.
I understand what they're asking, but you already have 50 feet.
Who has 50 feet? The roadway is 20, from my understanding, the roadway is 25 feet wide.
Okay.
And it's a
and that-
50 feet dedicated easement, an ingress egress
Okay, that's
easement.
exactly what I'm saying. You have 50 feet of easement. Are you going to widen this roadway? That's what I'm asking.
Who's going to widen it?
He's not.
Okay. Then why deny them what they're looking for? Since this roadway is not going to widen in any way, shape, or form.
That's not the application that's before this board. And that's what I was asking to clarify, Ms. Terrapini, earlier, that this is an application for a variance from the code as it's been determined by the building official to deny their permit for what they were looking to do. They needed to get a variance for it.
Okay.
Could I ask the same question in a different way? Maybe that could get some traction. The TRC had a request to reduce the 50-foot private right-of-way to 25 feet, and the TRC, I believe, approved it according to the backup, but it was rejected by one of the owners. Is that correct, Heather?
TRC did not request that it get, the applicant requested the reduction. TRC did approve it with conditions. Those conditions to date have not been met.
And that condition, one condition would be the approval of the other user of that
Agreed.
private right-of-way. All right, Mr. Zeller, could I ask you why you objected to a reduction of the 50-foot private driveway to 25 feet?
I have not commented at all. As a matter of fact, we had an agreement that after the completion of my construction, that I would contact my neighbor's counsel. I think at the time it was Mr. Kuskudis, and that we would then negotiate a possible redesignation of the drive. I have done so, and there's written correspondence on that. I was advised by Mr. Kuskudis first that my neighbors were out of town and didn't have time to discuss that, when in fact they were puttering in their backyard. And then the next correspondence I received from Mr. Kuskudis was that he was...
If you could just, so my question, your answer apparently is you might be agreeable to a reduction to a 20 foot?
I have made an outreach to counsel. They have then hired other counsel in Tampa. I've spoken with that lawyer. I don't know whether he is still their counsel. I've gone through 4 lawyers with my neighbors since.
I'm not concerned with what their position is. Your position is you might be agreeable to a reduction of 25 feet.
I might be agreeable to negotiating.
Okay, all right. That's what I just want to know where the foul lines are. Okay. Anything else from the board for Mr. Zeller or the staff? I'd really like to defer my comments. Any questions? Thank you, sir. All right, you may be called again. Any questions from the board from the applicant?
Just maybe a couple of clarifications.
All right. In the mic.
I'm sorry. You mentioned in Ms. Terrapini, your exhibit that you gave, page 1 of 6 on the second exhibit. I think you had mentioned that was given to your clients part of the purchase and part of the closing, and they had this document.
I think you're referring to Exhibit 2 in the package that you have in front of me and that we showed
Yes,
up here.
Exhibit 2, page 1 of 6.
Was the minor subdivision approval
Yes.
by the city? I do not know if they got that as part of their closing. I would assume that they probably did, but they're here. They can answer that question for themselves. Do you want to answer it, Vic?
Specifically, I'm just saying that Exhibit 2, page 1 of 6, it's pretty clear in this, when the minor subdivision was granted by the city, any single-family home constructed on parcel A1, I'm assuming is...
A1 is the Zeller home.
A1 is the Zeller home.
Yes, sir.
Has to comply with those setbacks, right?
Right, and the reason it said that is because there was A2, parcel A2, the home we're talking about today, already had a house on it. So,
right. So it kind of redefined, it kind of reestablished that we're talking about setbacks now.
well, what it did
Not
is
specific to whatever A2, if it was noted as A2 or not.
well,
At that time, there was already a house on the lot, but it was contemplated there that setbacks were being discussed, and
again, the setbacks are only discussed for parcel A1, which is the north lot, the Zeller house, because parcel A2, if you look on that specific purpose survey, A1 is the Zeller house, A2 is my client's property that already had a house on it. So they didn't set up the setbacks for that because there already was a house on it. But in the letter, they determined basically which was the front sides and rears for the north property because it didn't abut any right of way. So I'm assuming that they did it to clarify. Here's the setbacks.
Right. So your earlier testimony or fact finding was that you were trying to make some sort of correlation between the fact they were 33 feet from the east, which was actually closer than they complied. The Zellers complied with the setbacks.
Yes, I'm not
and
disputing
besides
that.
the fact that technically we're technically not supposed to, if they put purple on their house, we're not supposed to contemplate that. We're talking about that one address, so we're not really comparing they got this, they didn't get this. We're looking unique to the property, right?
We are, but I think the point I was you're right. And
Okay.
I'm not disputing that the Zeller home was built incorrectly. It was built properly. They got a building permit.
It just seemed like quite a bit of your testimony was like it was fair for them to do this, and it's now fair for your client to do that. And,
Well,
and
that is-
I didn't.
That is my point. On
Okay.
the Zeller property, in this minor subdivision approval, the city said, the setback on the east, which is where the easement is. Now, keep in mind, the Zeller's property, their easement is only 25 feet wide.
Right,
Okay.
and theirs is not on the east side. They have no easement.
Their easement
to have to-
is on the east side. Maybe we could put that, maybe I could put it back up, but yes, it's the east side of the Zeller house and the east side of my client's property where the easement and the driveway is.
It's actually on the southern corner of it, right? It doesn't go up. The driveway stops. Oh, it continues.
It
My
continues.
bad. My bad. I'm sorry. I was seeing all the drawings stop at the front of the driveway. So it does go.
Well, the first sketch that I showed you of our property does stop at our north property line, which is the Zeller's southern property line. The only point I was trying to make was, in the Zeller situation, the setback that was established was 25 feet from the east property line. The first 25 feet from that east property line is the easement on the Zeller's property. So they were not required to start the setback measurement on the inside edge of that easement and then go to the west. But our client is being required, we have a 50-foot easement, which we understand. I'm not trying to say that was a problem. But instead of saying that we get to count the setback starting on the property line, we have to go to the inside edge of the easement. That's the only point I was making, is that the city is treating two houses exactly next to each other with the exact same easement in two totally different ways. In one, the Zeller property, they get to use the easement and count that towards their setback. In our case, we do not. And if we are approved tonight, our request is to have the garage will be 50 feet from our east property line, 50 feet, and 60 feet away from our nearest neighbor, Mr. Licouris, and 36 feet away from our nearest neighbor to the north.
I also had one other question for council, is that if this variance was granted to the request of the applicant, does it matter if that building line is a garage or, as George said, a bedroom or whatever? What it does is it determines in perpetuity a new footprint.
Correct.
And so just because they're here today asking for going one story up, I don't know if they'll live there forever and ever, amen, but somebody in the future could go up 3, 4, or 5 on that same
Right,
footprint.
the height is not at issue tonight.
Right, the height is not an issue, but it does.
It's encroaching into the setback, that's the
It
issue.
memorializes forever a new footprint that's available, correct?
Yes, with the caveat that it depends. Because it always depends. But yes, for the purpose of this conversation, yes.
Okay.
May I ask the applicant a couple of questions?
Yes, sir.
How fixed in concrete are you to the 2 stories? Could you live with a 1 story?
That's
Forgetting
not part of
again,
the application.
if the applicant, assuming the city, I know that we just grant the variance and to the setback.
Not relevant, and it should not be inquired
Well,
about.
if they could voluntarily, I'm just asking a question if I could, will they voluntarily agree? There are 2 neighbors that object to the height. Would you consider just going to a 1-story structure?
Going to just a 1-story structure, again, as Ms. Aguelo stated, that's not part of it. We meet the height requirement. We're not asking for any variance to the height. We need that additional space for a variety of reasons for storage. And quite frankly, I just don't know how somebody who has whether you want to call it 2-story or 3-story, whatever you call it, you can look at those photos and they are 2 and 3 times taller than
We
our
have no
building.
jurisdiction over the height. I recognize that.
No,
I'm asking if you could.
If we don't get
Consider- you
get
can't.
the addition is so small, and then the second floor is relatively small too, because again, we cannot go into that driveway or the easement, which we will not do. So we can't live without both.
All right.
So again, the height's not relevant.
Ah,
and
yes,
so
I
even if
understand.
they built on the current garage, they have the right to do that.
I understand
they can
that.
go
I
up.
understand. Okay. So my second question is, are you fixed in concrete as to the size of the garage? Could you reduce that? You have a 2-car garage now, and you're making what I think is another 2-car garage.
No, it's basically going to be 2.5 wide, more or less, so that you can get 2 cars in there, and then the second floor. That's how it gets to the total square footage. It's It's not a 4-car garage by any stretch of the imagination. The other thing we're dealing with, and I didn't really talk about it because it's not part of the application, we're in the flood zone and we have a 1-story house that is not raised up and it does not have any fill. So we have, all of y'all know how that works. So there's only a certain amount of improvement you can do before you trigger full compliance. So we're trying to incrementally stay within the 50% rule for FEMA, put the garage where it should be, get some space for some storage, and keep all of our neighbors happy. And that's really all we want to do.
Did you plan, is that a load-bearing wall that you would, if the variance is granted, would you knock that wall down?
I'm not an architect or an engineer. I don't know. I can't answer.
Did we get an answer? It could make the garage a lot easier if there were no wall there.
It's not
You
part
can
of the
answer.
Not part of the application.
Well, it's a factor for me to consider. If, could you come up to the
Better come
podium,
up.
please, sir?
I'm Vic Randolph, live at 42 Riverside. I'm co-owner with Sally Diener. Which wall are you speaking of?
The one where the garage is. You know, if
Okay,
you're going
which
to widen
side
the
of the garage? Are you
garage,
talking about the west side or the east side?
be the east side wall.
Currently, it is not a load-bearing wall except for purposes of the roof. That wall is essentially going to be blown out. That will be load-bearing ultimately in terms of the expansion and in terms of what's going above it.
So again, then, if the variance were granted, you would remove that wall and have a much bigger garage. Is that a fair statement? Understand what I'm saying?
Yeah, well, it's getting not quite 12 feet wider, so I mean, that 14-foot entrance we have now will have an additional 8-foot next to it, granted the space that's going adjacent to it.
Okay, I think you've answered my question. Thank you.
In looking at, which I believe the applicant has provided, and again, thank you for color coding here, the addition that you are seeking approval for the variance to be able to construct is 12.5 feet to the east, and what's that, 25 foot 8 inches north-south? So that is the footprint change.
Yes.
Thank you.
I had a question. I don't know if you're all done.
I'm not done, but please.
Okay. Earlier, Ms. Tarapani, you said that there was posts blocking the existing garage so that it was not useful as a garage. Do you remember saying that?
It's the width of the door itself, because you've got, as you know, in a garage, you have a structure, and then you have the width of the door, of the garage door itself. That's part of the problem. In addition, they want the space to be able to move 2 cars in without having to inch in slowly and make sure they don't hit the other car.
So then I think what you're saying is currently the entry into the garage is on the east side of the home, and it will be reconfigured so the entry will be on the north?
No, ma'am, it's currently on the
Did
north.
I flip-flop that?
It's currently on the north.
Okay.
And it'll stay on the north, the garage.
Oh,
entrance.
gotcha. I'm picking up what you're throwing down.
All right, Mr. Eisner has the floor, so continue.
You could fool me. So one of the things that you also made mention about was that they're not having use of the reasonable use of the garage. And in this analysis, there's no place that it really says that. It says reasonable use of the land. So I was kind of curious why you would present it as reasonable use of the garage. There are homes that don't have garages at all. And I'm not saying anything on how I would vote or not. I'm just asking these questions just to see how you're going to respond to it.
I appreciate the distinction. Clearly, the use of the land in this case is for single-family residential. Most of the homes right in this immediate area do have garages. So the garage is, to me, a part and parcel of the use of that property, the use of that land. And again, for them, it's the ability to get a couple of cars in there and the ability to store the waterfront vehicles that they have. They have sports equipment for other sports. They ski, they water ski, they snow ski. They've got all sorts of equipment that they want to be able to store in this storage portion of the garage, as well as have 2 cars fit in there nicely and not hit the side mirrors when they pull in.
Saying that, I would have hoped that you would have brought a picture regarding that, so I would have a visual of that as well. If you have that, do you have a picture
of the existing garage? We can pull that back up.
of the north entrance?
I think so. I guess I don't have one face on to the garage, but I believe the Zellers might have provided something that shows
Talking about?
from their property looking back at the garage.
The only issue with this is it doesn't give me the size to know what is available, so. Windows I can count, but that doesn't tell me the size. Okay, I had one other question that was brought up, and I know we don't speak about height because that's not what the variance is about. And before I heard that, I had no issue with Section 5. I thought that you did meet criteria. But again, when it was brought up about that, it said, would it be affected by approval of this variance, which is I don't know the gentleman's name, whose wife sits across from it, it would affect their view, for that matter, to be a two-story structure over there. I know that we do not view that.
Right, for the record, it wouldn't matter because even if they built their current garage up or their current home up, they have the right to do that. So that doesn't factor into this variance application.
And with all due respect, we own the view from our property looking out onto the water. Anyone else who has that waterfront, the Zellers, for example, own that view, but you do not own a view across someone else's property. And I would also say, they own the property now. It is a FEMA, within the FEMA regulations. They could, if they chose, demolish the house and rebuild to FEMA, which would require either fill or elevating the site. Now, then are we going to have folks come in and say, well, they're blocking my view? I said, well, you had a one-story before. If you had approved the variance so we could get the garage, then maybe we would be back here for a new two-story house. But, and quite frankly, either the Deaners or someone else could do that, and they could meet all the setbacks, and there would not be a variance, and there would be no discussion with you guys about a view because you met all the setbacks.
Good answer. Thank you. My other big question that I'm trying to get through is when it was purchased. Because we do have many people come before this board to ask about variances prior to purchase, whether it's new construction, whether it's add-ons down the road. So the issue that I have in my head is that this property was known to have issues, for whatever you want to call it, with this, whether you want to call it a right-of-way or a easement. So why was that not discovered or gone into when it was purchased in 2016?
I do have the deed. I'm happy to present that into evidence if you like. The deed, and I'll just read it. It's a general warranty deed made on August 26, 2016, as Ernest Crivolone, a single man, as the seller, selling it to Victor Randolph and Sally Diener, of course, my clients here today. So that's August 2016. As I said before, these are smart folks. They understood and they investigated. They had a survey of the property. They had the minor subdivision. They knew that they had a 50-foot easement, and they knew that they had a driveway that they had to share and keep open for the property to the north. There's no dispute about that. They have no objection to any of that. They bought that knowing that. The only dispute they have is that the city decided to start the measurement of the setback, not at the east property line, where everybody else measures it from, but from the inside edge, from that at the 50-foot mark. So
Okay.
that's the problem. So it's not the easement itself. It's not the driveway itself. They're in agreement with that. They understand it. They know they have to maintain it with the Zellers. They understand all of that. The point is that instead of, and when they bought it, did they know all the improvements they were going to make? I'm sure they didn't, like most of us. It's an incremental thing. But they never anticipated that the setback would be measured from the inside starting at 50 feet inside their property. Everywhere else, you start at 0. You start at the edge of the property. So that's the problem.
So if with that being said, and this question is for you, and then again for staff afterwards. In Area 1, it says staff has researched this lot split and has not been able to identify any written evidence that the setback standard should not be followed. So, again, as much as I like your presentation, and I'd like to go with what you're presenting to me, how is it that staff can make that statement?
Well, I think the issue that you guys have to make a decision on your own is it an easement or a right-of-way? If it's a right-of-way, then we need a variance, and we're asking for a variance, and we've given you a variety of what we believe is good, legitimate reasons to approve a variance.
And to your point, Ms. Terrapini, I'd like to ask Heather again, since I asked you earlier about the letter that you wrote.
Don't
Are
mind
you
me just-
okay?
No, please, go ahead.
Well, you claim that it's an easement, and then you said that the city had to determine a right-of-way because that was necessary to create that entity, right? But right-of-way, a strip of land acquired by dedication, prescription, condemnation, or purchase for use as a road, crosswalk, railroad line, electric transmission line, or gas pipeline, or similar use. Is the city going to use any of these things on that quote-unquote right-of-way? Or was it only done on paper just so that they could create the entity?
I can't tell you for certain, but I can tell you my opinion, and my opinion would be that it was done on paper for the subdivision to occur.
Since the city is saying that they do not meet all the review criteria, and since the main review criteria is based on the measurement, then clearly you would go with the easement definition, since the right-of-way is a joke. Why would you measure it as a right-of-way when that is clearly not what it is? Thank you.
I do want to make a
Can
quick.
I try and step in here and
Sure, and
And,
Chairman, can I make a quick clarification?
please.
The interpretation by the building department is that this was a right-of-way. Am I correct in saying that? Okay, that this is a right-of-way, which is why the applicant is here requesting a variance. If the evidence presented meets the variance criteria, you can either choose to grant the variance, or if it doesn't, you can deny the variance. If you determine that there isn't a right-of-way, that it's an easement, which you're not being asked to do, then you need to deny the variance because the variance is not required. So then this board can't even hear that because there's no variance needed. So then the applicant would need to come before this board and ask for an interpretation of the code because they're appealing a decision of the building department, which is why I asked that at the beginning, which Ms. Terrapini said is not the case. They're just here asking for a variance.
That's what I thought.
And we insist that part of the special circumstances are the unusual interpretation of the city of calling this a right-of-way.
And
So
I would,
that's what I'm saying to you guys is that we're asking for the variance because, like I said, it was already submitted, the public hearing had been noticed. We thought we would just go ahead and proceed that way. I recognize we could have asked for interpretation, but I clearly thought with all the evidence that it would be seen that it is, the variance is justified. And I'm asking you all to grant the variance because it is justified.
and to that point, the first criteria is that the need for the requested variance arises out of the physical surroundings, shape, topographical conditions, or other physical or environmental conditions that are unique to the specific property involved. So I would just keep that in mind. So
if
we're
I
not
might just
asking for
say-
an interpretation. And I'm just
Sorry,
trying to
I
make the
didn't mean to
record from a legal point of view that we're not here asking for, Ms. Terrapini is not here on behalf of her clients asking for an interpretation of right-of-way versus easement. She's here asking for, on behalf of her clients, for a variance. So if it meets the criteria of the variance, you can grant it. If it doesn't, you can deny it. If you're saying that a variance is not even needed, then this board can't hear that, and she needs to come back for an interpretation of the
And
code.
what I'm saying is what's unique to this case, and I think we've demonstrated it based on a property immediately to the north, is that in this case, not only do I have an unusual shaped property, it's got a narrow throat, it's got an unusual shape, but in this case, uniquely, the city is requiring the setback to be measured from a different place. That creates a physical problem with where, the only place to put the garage is where we've demonstrated. I think everyone's in agreement with that. But the physical problem, the physical uniqueness to this site is where the city is requiring the setback to be measured from. So we're asking for a 0-foot setback. City, I don't agree with the city's interpretation, but we're asking for that setback as a 0-foot setback.
May I say a few things, and I hope I can get through it without too much interruption, but first of all, an easement is a relatively permanent right to use the land of another for a specific purpose, like water, sewer, gas, sunlight, preservation, transportation. And if it's transportation, the right to walk or drive or bicycle across it, it's called a right-of-way. Some easements are private rights-of-way. Some easements are for private right-of-way and some are for public right-of-way. This is an ingress egress easement, go in and go out, private right-of-way. In my understanding, I think that's what the documents state. It's a private driveway. And to me, 50 feet is too much necessarily for two houses. And I have no problem with the staff's interpretation that it should be measured from the near edge of the right-of-way line, not the far one. But I also have a problem with the fact that it's 50 feet wide. In fact, the TRC, I believe, agreed that it could be 25 feet wide. And apparently the neighbors, or at least conditionally, I don't want to put words in his mouth, are agreeing to go with a 25-foot wide private right-of-way easement. My house, I lived for 45 years, it serves 4 houses, and it's a one-lane street about 12 feet wide. And everybody's happy. It's never been a problem. I've never seen 2 cars on that street in my 45 years at one time. 2 cars at one time on that street, I should say. And people walk on it, there's no sidewalks, and it's fine. So I don't think that this 50-foot is... the code requires 50 feet, and we've always talked about flexibility. And we're trying to get some flexibility that makes sense. And to me, 50 feet wide in this particular situation is too wide, and I hope that the neighbors would agree to it. And if it's 25 feet, then you would measure it from the near property line, the near right-of-way line, not the far one. When a property, when it is dedicated, and then it's public right-of-way, and then vacated, then the property goes in proportion to the dedication. So typically it's 50-50. When a city vacates right away, half to one side and half to the other, but not necessarily. If there is no dedication, of course, so there's no vacation required. Another example is if a buried treasure is found underneath a public right-of-way, the buried treasure belongs to the adjacent property owners of the fee simple title. You have fee simple title, generally speaking, to a halfway midpoint of the right-of-way, subject to the public's right to go across it, called a public right-of-way. In this case, again, it's private. And the state definition, I just pulled the state statutory definition of a right-of-way, corroborates that. Right-of-way means land in which the city owns the fee or as an easement devoted to or required for use as a transportation facility. So this is a private right-of-way easement, ingress, egress easement. I hope that clarifies, in my judgment anyway, with the...
Mr. Chairman, are we still in the public hearing?
No, I haven't closed the public hearing, but we're talking.
Well,
and everybody's
well,
talking, and I've held it.
And I understand, but you're now testifying in a public
I'm
hearing.
not testifying. I'm trying to
If
clarify
you'd like to be sworn, I can certainly do that, or we can close the public hearing and you guys can have discussion.
No, I'm trying to use, again, I didn't want to get into a legal argument, but just from common experience, this is what we're talking about. The language has been floating about. Is it an easement or a right-of-way? A right-of-way, I'm trying to say, is a kind of an easement, and the statutory definition in the state corroborates that. Let me see if I have some more. Can the front of the house, apparently, for this particular house, is the southwest right of way, is that right? The south entrance is the, is the front setback is different from the south entrance. Now, I haven't been in that house in 30 years, but when I did go there, there was always the front door was the front of the house, and Mrs. Terrapini did state that the front yard is the, Cindy, before you, I'm going to ask the staff a question. In the backup materials, there was no definition for a front yard. Do we have a definition for a front yard in the, we need to clarify that as to what's the front of the house, if possible.
While they're looking that up, the front door is on the east facade, but I believe she's going to tell you the front setback is where it's adjacent to the right-of-way. And the only right-of-way that this side is adjacent to is Riverside, which is a southern property line.
Only public right-of-way, but the private right-of-way is on the east side. I don't want to get too bogged up in that because whether it's the front or the side, I want to just get to the merits of it and say, is this the appropriate place or size structure? So, have you got that yet? There.
1 second, I think it's under yard. Okay. So it's the front yard, so it's under the yard section, but it's getting where you're trying to go. A yard extending across the full width of the lot or parcel between any structure and the front lot line measured perpendicular to the structure. On a corner lot, the front yard shall be determined by the location of the principal entrance to and the primary orientation of the structure, which is most often facing the narrowest width of the lot.
Okay, now, do you have an opinion as to where the front of the house is? I think the definition says the front of the house is the front of door or something like that. They use front in the definition as the definition for the term.
It's telling you the primary orientation of the structure or principal entrance.
So that would be the east side is the front yard by definition?
I think for their determination, they were allowed to use the primary orientation of the house, which was on Riverside, I believe. That was their front. That was the determination for their front, and the attempt was to try to make it work for them to not have to go through the variance process. So that's where that orientation difference came from. But again, their garage is not oriented that way. Their house is oriented that way. Because the house was oriented on the original lot that was there, which was the larger lot that was subdivided.
So if the front of the house determines the front yard, that would be on the east side. Would that affect your opinion at all?
It doesn't affect my opinion for how we're measuring this. They need variances based on the way we have interpreted the code. Whether it's the variance they're requesting in this case is the rear and the east side and on the one side, and then on the side lot line on the other side.
That's good. Yeah, I don't want to get too bogged down on where the front is. It's very complicated.
Well, just the front lot line, by definition, is the lot line separating the lot from the adjoining street right-of-way line.
That's in our city code?
Yes.
That's the one I just.
That's how you decide the front lot line. So that's why the southern edge is the 25-foot setback. Opposite that is the rear, which is 30, which we don't meet. We're asking to be 26. And then you have two sides, east and west.
I thought it.
Nobody's arguing that. The
Okay.
applicant or the staff are
We're not-
arguing.
Okay.
we're not in- we're
Well,
not in
the
dispute.
definition I thought I heard was the front door is the front of the house. But that really is, I don't want to get too bogged down in that. That's more academic than solving the problem.
Well, and we're not here to solve a problem. You're here to apply the facts to the criteria in the code and make a decision.
All right, well,
Variance request.
so since we have no problems, then let's hear from the board.
Okay,
Before we close the public hearing, I want to hear from the board.
the point that I want to make is this.
Before there's
Okay.
discussion on the application, we need to close the public hearing unless there are any more questions of the applicant or staff. And then I would say that the applicant and staff each have the opportunity to make a final closing argument, and then we can close the public hearing.
I have a question for staff. As you have the entrance at the property line, would you say it's approximately 35 feet?
Sorry.
It's okay, I just need to be able to see, because
If not less?
well, it's 15 feet from the front property line, but again, this is
How,
what,
how wide is the property? The easement, how wide is it at that point? About 35 feet, would you say? 30 feet as you enter?
I'm confused, Mr. Burris. What is your
Okay.
question?
As you enter the road from Riverside Drive, what is the width of this easement that we have?
50 feet.
Is it 50 feet? The same 50 feet you have up this way?
Correct.
Okay. If we take an arch from this and cut that corner up that's in at the front door of the house, the walkway basically that you have here, will that be a problem for the city?
No.
In other words, back off the easement a little bit.
But that's not before
That's not
that's
the,
part of this variance application.
you can't accomplish that here tonight.
Okay.
And I appreciate that you guys are trying to find solutions, but that's not the charge of this board. The charge of this board is to apply the evidence to the criteria in the code.
Thank you. All right, any further questions from the board to the applicants or to the staff?
And I believe this may be a staff or council question or point of clarification. We had talked about, there seems to be the challenge within the interpretation of the code, of whether or not, the definition of right-of-way versus easement. So if the applicant, you chose not to approach the city to address the interpretation.
Right. They are not appealing the interpretation of the code by the
Right.
building official, which means that it is considered a right-of-way per the building official. If they were to appeal the decision, then this board could determine whether or not it was considered an easement or a right-of-way. But for purposes of this application, the building official has determined that it isn't a right-of-way.
Does the applicant have the privilege of removing the application that is before us to then approach the city to request the review of the interpretation?
Yeah, I mean, the applicant can withdraw their application at any
They don't
time,
want to.
but, I mean.
To withdraw the
that's-
application
They don't want
review?
But, well, I mean, if that's what they want to do, but that's not what they're here doing. And by all means.
Jackie, are you asking kind of the same question I have? Ms. Terrapini said before this was their last resort, and I'm wondering if this is their last resort. That was kind of
I
where you're
believe,
going.
yes. Because then if the city said, we see where you're going with this, we see that, yes, that maybe this interpretation is not on par.
The city has already made the determination. They've already interpreted the code. What would happen would be that they would request of this board an appeal of that interpretation.
But then also,
But that's a whole different proceeding.
if I may, could not also the fact that it has been viewed as a right-of-way not be considered physical or environmental conditions that are unique to the specific property involved? Because they clearly are. They're unique to that property.
But they're not, because the next door neighbor has the same right of way.
It seems to me that it is a physical or environmental condition that's
He feels it.
unique to that property.
If that's how you're interpreting it, then that can be part of your discussion. Are there any more questions for the applicant or staff? Well, are there any more questions for the applicant or staff?
No, but we're going to allow.
Right, I was
Okay.
gonna say there can be a closing argument made from both the applicant and
And I have none, Cindy, so.
I'll try to be brief. The reason I said this is our last resort is because for over 2 years, probably 3 years, my clients have been trying to figure out a way to build the garage. First, they asked the city, they saw it was an easement on their survey. They went to the city and said, well, can we vacate this easement? You have the letter from the city dated May 2017, I think the year is, saying, we can't vacate it because the city has no interest in it. That was round one. The second option they chose, I'm not sure if it was a city suggestion or not, but anyway, they said, okay, well, let's go talk to our neighbor and see if, since we have a 50-foot easement, my clients, and the Zellers to the north have only 25, maybe we could just make it 25 the whole way, and that way, the city, where the city wants to measure it from, we wouldn't need a variance. We would need it on the north, but we would not need the east variance. I have seen correspondence, which I did not present because it is private, between my clients and the Zellers, where the Zellers had made it abundantly clear that they had no interest in cooperating in that in any way, shape, or form, regardless of what he said tonight. Not really sure that he has a legitimate change of mind, but my point is, for 2 years, they tried that option with their neighbor to the north. That is why we are here. Now, again, they filed this application before I was involved. As you all know, we came to you in March. It was advertised. We came to in March, and there was not a full board. So we did request, and you all were gracious enough to grant us a variance when there would be a full board to hear, because there's a lot of complications to this. And I think you all will probably agree it was good to have a full board. So do we want to start over and withdraw this and ask for an interpretation? No, we really don't. We really just want to build a garage. We just want to put our stuff inside. We want to be able to build the garage. We're hampered by FEMA as well. So I appreciate your idea. You know, if I had been involved at the beginning, we might have pursued that to start off with, because there's a lot of intellectual arguments to that I think the board, might be interested in. But like my grandmother would say, you got to dance with the guy who brung you. We're dancing here tonight. We have a legitimate request. I think we've showed you abundantly that we meet the criteria. The staff agrees we meet 2 of them. And the one that they don't agree we met is because of their interpretation that they're saying that we don't meet it. So I kind of feel like we're in this catch-22 or a do loop, and we'll go do something else. That's why we are truly here at a last resort, to try and get a variance. We do not want to start over with an interpretation. That'll be at least 2 months from now before we can get back, in this front of this board. And I understand you may be sympathetic to that, but again, we have provided you evidence that it meets all 5 of the criteria. The staff says we meet 2 of them, and we provided evidence we meet the other 3. There are special conditions unique to the site. We did not create them, because the site was set up with that minor subdivision before our client even bought it, and I have the deed to prove it. And the last one, we also meet. We're not going to have a negative effect on anybody's property value. I don't know how we could, when our building will be further away than our neighbors are to us. So how can we have a negative effect on someone's property value? So again, we believe we meet all the criteria. We are before you on hands and knees, really asking for your help to be able to simply build a garage just like everybody else, just like exactly what our neighbors on the north and east have, and exactly like the neighbors around us have as well. I'm happy to answer any question.
I have one more that I hesitate to get into. It's really not pertinent too much, but it's a procedural point. The placard sign has been down for a few weeks. When I've been out to the property, I haven't seen it. And then today, it was lying face down at Riverside. Is there an explanation for that?
It came down during the weather, and it was brought to my attention late last week by Ms. McNeese, and my client reposted it. They frankly thought that the city was going to come post a new one with the new date. So it did not instantly go back up after the weather hit it, but it was reposted. And you can see clearly.
I don't want to belabor the point
Okay.
and run into the ground. That's enough. I'm okay with that.
Okay, thank you.
And thank you
It's
for
never been the staff has said it's not jurisdictional. We have to still hear the hearing, but it's a factor to me to a certain extent. that the
It has
sign.
nothing to do with the criteria in the code.
Thank you
Well,
for your
the
succinct
ordinance says this property shall be
clarification and
posted, and
There
the
was
sign
a
was,
very strong storm.
yeah, there was, but the sign was suddenly back
understand.
today, lying
Right.
face down, and there was no storm.
Well, considering that we had statements from all neighbors.
Yeah, I'm not, again, running that into the ground.
So are we closing the
Okay,
public
all right,
hearing?
so then, no more questions of the applicant or the people in the audience?
We've
Wish to
already-
make a statement, sir?
We've already, he does not have the opportunity to make a closing statement. We've already had a closing statement by the applicant and staff has deferred.
I don't like to shut people up if we don't have to. Can we give them a couple of minutes, please? Does the board have any objection to that? I'd like to hear what everybody.
Procedurally, you just talked about procedure. Procedurally, that's improper. If you want to give him an opportunity, then we will give the applicant and everybody else in the room
Yeah,
opportunity.
of course, we'd
as
like to
well.
hear everybody, so please, sir,
Okay.
I want to give everybody a fair chance.
Thank you, and I only have one sentence, and it's not with respect to this variance. I just want to address Ms. Terrapini, and ma'am, I'd like to remind you that you're under oath, and I would hope that you refrain from making statements about attorney-client privilege, hearsay information that you supposedly have or you don't have. And,
All right, we're not-
And I do not appreciate the comments that you made about me and
All right, sir, thank you.
the statements I supposedly made.
Okay. Anybody else wish to make any comments? Then he's had the right, so I want to give it to everybody else. Seeing none, then the public hearing is closed, and we're ready for comments from the board, and perhaps a motion. Comments first, perhaps? Anybody? Alternates are welcome to speak.
Okay. Curious
Okay.
about some of the things that you said, Mr. Chairman, about right-of-way versus easement.
What's that?
Well, there was some evidence presented that perhaps they get a tax break on their easement, right? Does that mean that it has been purchased by the city or the county?
No, again, it calls on my experience as a special master for the property appraiser's office. Property appraiser's office must consider easements that affecting the property value. So, and they do, if they know about it, they will reduce the assessed value to reflect the value of the private right-of-way taken. And in my experience, they've done that. Does that answer your question?
Yes.
Was that assessment changed when the new home was built?
Well, the assessment changes when the property appraiser's office knows about this private right-of-way and is asked to make a reduction. And I've done it myself with clients. When there's a drainage easement and the property appraiser didn't know about it, they will make an appropriate reduction.
And yet you said that they should take the other measurement.
Well, the measurement typically is from the near side of the public or private right-of-way line, not from the far side.
But if it was an easement, it would be the part.
It is an easement. It's a
Right.
easement for private right-of-way. The right to use someone else's property for a particular purpose, in this case, transportation. But it's only for two houses.
Yeah, I want to point out to this.
Can you on the mic, George?
Yes. How come the easement didn't extend to this side, to the east side of the road, 25 feet? And why the road wasn't put on the center of the easement rather than on the right side or the east side?
I don't think that matters. It doesn't matter why it wasn't done, whatever way it was done. The only thing that matters is that it was done, and that is part of the evidence that's on the record. It doesn't matter why it wasn't done a different way. That's irrelevant to the application.
Private driveway is in the private right-of-way. Did that answer your question? Yeah, it's a private right-of-way for two houses?
It just seems that this house here paid, is holding the onus for the whole thing.
Any other, ready for a motion, maybe?
Motion to approve.
I second.
Okay, there's a motion by Ms. Turner, second by Mr. Burris, to approve the variance as submitted. Discussion on the motion.
Did you want me to share
Well, I
that
may-
this is a very difficult case?
Yeah, my compliments to everybody for playing by the rules and listening and being fair, and I hope that we will all leave this room as friends and neighbors. And to me, if this east side is the side yard, and it's going to be 23 feet from the edge of the private driveway, that would meet the typical, exceed there, the typical side right-of-way line. It has to be in R100 a total of 25 feet, is that right, Heather?
That's correct.
And this would be 23 feet from the edge of the road, and to me, the road is plenty wide for these two houses, and this extra 50 feet is unnecessary, should be much less, and hopefully that people will agree to do so in the future. Any other comments on the motion? Can you get on the mic, please?
Just for clarification, are you saying then, in your opinion, you're going against the staff's recommendation for the number 1? I'm just interested which number you're talking about.
Okay, the maker of the motion?
The motion is for the application as a whole.
I think the question was the rationale,
Yeah.
the discussion that the chairman just had, which criterion does that apply to?
I am comfortable with the side yard setback being 23 feet from the edge of the right-of-way.
That's not.
Which condition? She wants to know which condition.
Yeah, which criteria does your analysis go to, is what I believe the question is.
Well, I just made a comment, really, the motion was to approve, and it should be commented by the maker of the motion.
She's not questioning my motion, she's questioning your comment.
We're in discussion right now, so you were having a discussion item on the motion, and your fellow
Well,
board member
rather
just
than-
asked what criteria that applied to.
I don't know how germane that, I'll just withdraw my comments then. Solve the problem. Ready for a roll call vote, please, then?
Ms. Turner,
Approve.
Mr. Eisner,
No.
Mr. Burris,
Yes.
Mr. Urbowski,
Yes.
Chairman Elliott.
Yes.
Thank you for your patience.
Pursuant to our rules, you're entitled to make a comment after the vote. Did you explain your vote if you want to do that?
Yeah,
No?
anyone can do that if you wish, but
Any
it's
reason?
not required.
Oh, I'm happy to explain my vote. I just didn't
Can
see.
you get on the microphone, please?
I'm sorry. I just didn't see that the rule, the variance, the criteria for 1, 2, or 3 were met. That's where I had to stay with, so. But
Anybody else wish to explain?
I know it was a very difficult case, that I'll say.
Okay, then, all right, so the variance has been approved, and you have 2 years to pull a permit, I believe. Thank you very much, everybody. Okay, the next item on the agenda is approval of the minutes of the last meeting.
Are you asking for a motion?
Yes. Be nice. Motion.
Should be easy. Motion to approve?
Do we have a second on the motion?
Are we still reading the minutes?
Just to approve the minutes, you guys. This should be the easiest thing that you do all night.
Are we reading the minutes?
I guess we have to make
So-
an adjustment. Yes, I did miss this. Mr. Burris adjourned the meeting at 7:40 PM. I believe that the
That was-
chairman was present at that meeting.
We fixed the last page.
So we can,
Hard to distinguish the two.
so would the motion maker please,
Well,
make
there
that
was
little
not
adjustment?
a second yet, so.
That's right. You want me to remove it? I'll remove it.
The motion fails for lack of a second. Is there another motion?
Let's make a motion to approve with the correction.
Seconded.
Second, Mr. Burris.
I
All in
still
favor,
don't see
say
the
aye.
difference.
Aye.
Aye.
Okay. Staff comments,
None at this time.
board comments. We have any items for next month? Anybody know?
I believe there is 2 items, I think, that'll be coming forward. All right, well, maybe 3 according to the secretary.
All right, so we will have a meeting, and hope we all can be there. Thank you all for coming. Meeting is adjourned at 9:10.